What you know, Alibiers. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It is Tuesday, January 7th. Hope you guys are having a good week so far. Last night, I was going through the filings in Donna Adelson's case and saw that I missed a couple of things that dropped right towards the end of December, just in the craziness of the holiday season. I didn't see it. So we're going to go over those today. I'm also going to do a second episode later, reading through the latest filing from Charlie Adelson's case, where he's asking for resentencing. And we'll go through that whole filing. But let's jump into what we've learned since towards the end of December. Investigators requested a search warrant for Charlie's email addresses. And here's one little tidbit from that filing. It says a report was generated for review of Donna Adelson's emails received in April of 2024. The state has reviewed Donna Adelson's emails, Wendy Adelson's emails, as well as Cellbrite reports from the phones of Donna, Harvey, and Wendy Adelson, along with the iCloud return of Charles Adelson. Emails have played a critical role in the state's theory of the case. Emails between Donna and Charles Adelson were observed in the return from Donna's email search warrant. These emails were not located in any other device or search warrant previously served. Due to Charles Adelson communicating with Donna Adelson via emails that had not been previously observed, investigators are requesting a search warrant for Charles Adelson's email to locate any and all communication pertaining to the murder of Dan Markell. There was a new in-camera hearing minutes document uploaded to her case. The date of that hearing was September 6th of 2024. This would have been before Donna's trial was delayed, and Rashaum and his co-counsel were still on her case as her defense attorneys. This in-camera hearing is regarding a sealed motion in limine concerning the testimony of Robert Adelson, which is Donna's oldest son. They start off talking about the defense motion concerning the testimony of Robert. Rashaum says he thinks it pretty much speaks for itself. The papers, we filed them first in response to Ms. Dugan's concerns. I think we've alleviated those issues. We don't plan on eliciting that testimony unless something unforeseen happens at trial. The judge asked, why would someone need to use slurs? And Rashaum says he can't imagine a situation where it would come up, but if it does come up, they won't do anything before alerting the court first, as well as the state at a sidebar. I don't know what this slur is about. It doesn't list in these minutes specifically what they're talking about. But Rashaum goes on to say that the last thing anyone wants is a mistrial, and with this particular witness, given his relationship with the defendant, that would be his mother, if there is a misstep here, it would necessitate a mistrial. Rashaum says they've summarized every statement he's made, and they've isolated it for the judge and the state into 3 categories. And they showed why Robert's opinion testimony is not admissible. And they took a third component, which is potential admissions, and provided they're elicited the right way. We don't have an issue with those statements coming in, but we painstakingly did this to try to avoid any issue at trial, because I don't think anyone wants that. The judge wants to start with the first category of just pure opinion that might come with Robert's testimony. He asked the prosecution if they plan to elicit this in this way. Ms. Dugan says Robert Adelson did provide a lot of opinion in his deposition, but he was also asked his opinion and why this, why that, and why did he bring that to law enforcement attention or whatever. I won't be asking him any of that on the stand or his opinion about anything. Kind of curious, what did Robert bring to law enforcement attention? Maybe we'll learn at trial. But the judge says, as a matter of law, no witness gets to come in and just wildly say, I think the defendant's a murderer. Ms. Dugan says she only plans to ask Robert of his observations, things he has personal knowledge of, and the defendant's admission to him. That's very interesting. The judge asked if the state plans to get into Robert's relationship between him and his mother. The judge said this is the second issue that the defense raised in their motion. Ms. Dugan says in the deposition, they asked him if Donna was pretty sharp or is she someone who's gullible? And he said, no, she's very sharp. She's not someone who is gullible or could pull the wool over their eyes easily or something like that. He would have personal knowledge of that from knowing her, but she says she doesn't plan to ask anything about prior bad acts of her helping conceal a crime. Defense attorney Morris, who is with Rashaum, said Robert's answer was actually a lot more inflammatory to that question. It was, there's no person who places their own interests first than Donna Adelson or something like that. Prosecutor Dugan said she would just let him know it's just the question of, is Donna sharp or is she gullible? Rashaum said he doesn't think it's admissible, period, because while Robert is a doctor, he's not a licensed psychologist. The judge tells defense attorney Rashaum, as part of the state's case in chief, you may be correct. Depending on what comes out during the defense case as a matter of rebuttal, if any of the arguments are ignorance at that point, it's fair game, and Rashaum agrees. Prosecutor Dugan asks if Robert living with Donna for 18 or 20 years provides him with the personal knowledge of whether she's someone who is gullible or not. The judge said the context of how you want to use it, I think, really comes at issue with that. Obviously, the mother-son relationship, him knowing her, having intimate knowledge of her, is going to satisfy a certain foundational basis. He goes on to say, without knowing, I can't compel the defense to show their hand, nor am I trying to. He says a better way to ask this is, which aspect of either the elements or the state's theory is this going to cover as part of the case in chief? Ms. Dugan says prior knowledge of the conspiracy. And Rashaum said Robert has no knowledge as to the crime, and he says that in his deposition. Robert saying, I think my mom's a very smart woman is not relevant towards whether she did a murder or not. He says, let's not hide the ball here. We know why they're calling him, because they want the jury to know without him saying it, because they're not allowed to get it from him because it's opinion testimony. That he believes his mom is guilty, that's essentially what they're calling him for. And to show there's a negative relationship between him and his mom, which is highly prejudicial to us and not probative of anything. We're asking the court to limit the testimony to what she said to him. His beliefs of, is she smart, whether she's stupid, gullible, what she is, how she acts, it's not allowed because it's highly prejudicial to the jury. And it's not evidence of anything. It's not relevant. And when you do a balancing test, and then Rashaum said, I love those words, balancing test, it doesn't survive. He goes on to say they're calling him as a show to the jury. I understand the things she said to him are admissible, but the court should protect her rights to this jury being prejudiced by them being able to show inadmissible evidence that this son has an axe to grind against his mom. The judge says, as to 16, I believe this came up at the last trial, whether Ms. Adelson is an overly involved parent, and this one strays the line somewhat between fact and opinion. If Robert has a foundational basis to establish this, knows that his mom was either involved in the life of his other two siblings or himself, and to that point, he can testify factually if asked questions, and Rashaum agrees. The judge asked Prosecutor Dugan if, in regards to whether Donna is intelligent or gullible, is there a basis in which she wants to proffer this line of questioning? He says he'll reserve ruling on it until then, but he will also find that if the defense deals with ignorance or lack of knowledge in some way, at that point, it's fair game for rebuttal. So it's a little hard to know exactly what we're talking about here because we don't have this filing. It's still under seal as far as I can tell, but it says, as to the admissions, all of which are identified as 21 through 30 in the motion, is the state planning to offer those? Prosecutor Dugan said not all of them, but several. The judge says, as to those admissions, how and when they took place would be foundational parts, but as long as that can be satisfied, their party opponent admissions. He asked if there's anything else to address with this motion in particular. Prosecutor Dugan says just as to the alleged derogatory term, she said she appreciates the defense filing their motion on that under seal and says her motion in limine that she brought up the week before was to not only ask Robert about it, but also ask any other Adelson family member about it So that would be her motion in limine as to eliciting it from anyone. Rashaum says they wouldn't ask that of anyone unless something comes up, and they'll just come to the court before they do. The judge says because of the highly inflammatory nature of putting a racial slur before the jury, I can't imagine a context in which this would occur. If it comes up, they'll need to handle that at a sidebar. They move on to another issue, which is defense attorney Morris saying the state intends to ask Detective Isom about David Marcus calling him shortly after Katie Magbanawaz's arrest. The sequence of things as we understand it is David Marcus, Charlie Adelson's attorney, is sitting in the office of the partner of Katie Magbanawaz's lawyer when she's arrested. The partner calls the other partner, and Mr. Marcus learns of Katie's arrest. So he asks for the phone number of the investigator to call on behalf of Charlie Adelson. Mr. Marcus is under subpoena, and he's going to file a motion to quash. The state indicated they wanted to seek to elicit that, but I think the state's theory is they were all in cahoots with lawyers and financing lawyers, and it was one big part of the conspiracy, but the evidence seems to be to the contrary. Prosecutor Kappelman says she is seeking to elicit that, so they'll need to have Mr. Marcus if they feel that's appropriate. The judge says as a factual matter, him having knowledge of the call or the arrest, he doesn't see where that would go to any privileged information, and asks if it goes beyond the factual detail of how he became aware of Katie's arrest. Defense attorney Morris said no, it's just the sequence of it. If it's at least a loan and the defense doesn't do anything, then there's an appearance of improper conduct. And so Mr. Marcus would testify just to that, not interactions or discussions with his client. The judge asked Prosecutor Kappelman if she's planning to elicit any more than the factual chain that went down. And she said if Mr. Marcus testifies, that's where he was. She may cross-examine him on that point and potentially have more evidence on that issue. But she says she hasn't thought that far ahead, but that's not her understanding of how that occurred. So she really just doesn't know the answer. The judge said that really needs to be reduced to writing and says for them to prepare a motion. Rashaum says he's letting the court know that when they bring that up, we have him under subpoena and he's going to move to quash, we're told, but we've told him our questions we would ask him, which have nothing to do with communications he did or didn't have with Charlie Adelson as Charlie's attorney. Rashaum says he's not sure where the state's going with this and whether that's going to turn into questions, but they do have Mr. Morris on the defense witness list, and he was Charlie Adelson's lawyer. The judge asked the defense if they're wanting to know if the state is attempting to pierce the privilege for some reason, and Rashaum says, yes, we don't know. Prosecutor Kappelman says, I think the answer is no. I wouldn't ask about any communications with his client. The judge ends this by saying, as to other matters that may be relevant, which he has factual knowledge of, he can be called like any other witness. So some interesting little nuggets in there. It can get confusing when you don't really have the context of the filing. It's not a secret Robert's not a fan of his mother. To me, I kind of took this, did Donna admit something to Robert? Also, the emails, that is very interesting. What did they find when going through Donna's emails? That's it for this one. Hope you guys have a good rest of your afternoon. We will see you soon.